pass it off right now to my colleague, Marco Allereid-White, who's an attorney at the Center on Law and Poverty, to talk about the changes to food assistance that are happening that are requiring increased work requirements. So I'll turn it over to Marco.
Thank you, Sal. And thanks everyone for being here. So SNAP, or the Supplemental Nutrition Assistance Program, formerly known as food stamps, is a federally funded program that helps families buy food by providing them benefits on an electronic benefits transfer card, an EBT card. And that benefit can be used at grocery stores to buy unprepared food. So there are four requirements people have to meet before they can get SNAP for themselves. They have to have income below the level that qualifies. They have to be a resident of the state of New Mexico. They have to meet citizenship and eligible immigrant status requirements. We'll get into that in detail later on in the presentation. And if the rules say that they have to meet work requirements, they have to prove that they are meeting those work requirements to stay on SNAP. We'll talk about that as well. Um, so families that qualify for SNAP, here on screen we have a chart showing some of the basic um, federal poverty guidelines that people have to meet. So families have to meet two applicable income tests to get SNAP benefits. Those income limits are based on federal poverty levels, which are updated every year and are based on an amount of money that the entire household brings in. So first of all, households have to meet gross income limits. So that looks at your income just before any deduction is just everything that comes in. New Mexico uses a 200% of the federal poverty guidelines limit for that overall gross income. And again, those federal poverty guidelines are just updated every year. If you meet the gross income tests, then you have to apply all the deductions that get applied to your household for, housing costs, utility costs. And once all those deductions are taken out, your income has to be below 100% of the federal poverty guidelines. And then the final amount of your benefits gets determined by how much income you have. The lower the income, the more benefits you'll get. The higher your income that still qualifies, the less in benefits you get. Next slide. Thanks. So families that qualify for SNAP with very little income or people who have housing costs that are higher than their monthly income have a right to what's called expedited SNAP. And this means that they have a right to have their applications processed faster and they have to get benefits within 7 days of applying. And so the written answers on the application and the applicant's answers in an interview are all the information that's required to get approved for expedited SNAP. And then proof of income or other documentation that the applicant might need can be provided after that expedited approval. Okay, so now we're getting into the federal changes. So last summer, federal bill called House Resolution 1, sometimes referred to as OBA or One Big Beautiful Bill. Not beautiful, HR 1 is probably more accurate. It made some very significant changes to the SNAP program that went into effect beginning this year. Those are effective for people as soon as they apply for the first time or as soon as they renew SNAP benefits after that January 1st date. So someone who was on SNAP and they renew in March, that's when those changes become effective on them if their eligibility changed or if work requirements changed. So the main changes in that bill are that fewer non-citizens are able to qualify for SNAP and many more people are subject to work requirements than they were before. So I'm going to discuss a little bit about what those expanded work requirements look like. So who do they apply to? They apply to a lot of adults age 18 to 65. It used to be adults who don't otherwise qualify for an exception who are age 18 to 50. It's now up to 65. So the rule requires that those subject to work requirements have to participate in training programs They have to volunteer or they have to be working for pay or for in-kind payment for 80 hours a month. And you have to prove that you're doing this when you either apply or when you recertify for your benefits. So if you do not comply with the work requirements, you lose SNAP after 3 months of not complying. 3 months of not complying, absolutely. So if you don't comply for 1 month, you work for the next, and then you don't work for 2 months, you'll get kicked off of your SNAP. Um, and they can be reset after a lockout period. We'll talk a little bit more about that lockout period in a minute. So there are a lot of different exceptions that can get um, people out of having to meet the work requirements. You're exempt. Well, if you're working 20 hours a week, or if you're earning the equivalent of minimum wage, $217.50 a week, you already meet the requirements. If you're outside the age range, you don't have to meet work requirements. If you're in the same household with someone who's under the age of 14, you don't have to meet requirements. Pregnant people, if you're what the rules define as unfit for work um, due to mental or physical impairment, you do not have to meet work requirements. We'll discuss that definition in a minute. If you're taking care of someone who requires a caregiver, if you're enrolled half-time in school or training, if you're participating in a drug or alcohol treatment program, or if you're applying for or receiving unemployment, SSI, or general assistance. So importantly, anyone who is Native American, if you're a tribal member, if you're an California Indian, if you're Alaska Native, basically, if you have Native American heritage, you don't have to meet the work requirements. Or if you are living in a waived area within the state of New Mexico, there are 5 waived areas. That's Luna County, Laguna, Taos, San Felipe, and Suque Pueblos. Previously, there were a lot, most of the state was under a geographical waiver. Now it's just these very limited regional areas. But if you're not a tribal member and you were living on, say, Taos Pueblo, you still would not be subject to work requirements. So how do you qualify for an exception? So if you believe an exception applies to you, you all you would have to do is to tell the state agency that you qualify for that exception. We have a form on our website that we'll share after this presentation that families can use to let the state agency know when they meet an exception. The only time you need to provide proof is if the state agency um, has reason to doubt what you're telling them. And if additional proof is needed, like documentation that you're in a drug or alcohol program, the agency has to ask you for that proof in writing. Okay, so specifically for people with physical or mental impairments, disabilities that make it difficult to work, you will not be subject to the work requirements if you're disabled under this definition. And this definition of disability is much broader than a lot of other definitions. To meet this disability exception, you just have to show that you have a temporary or permanent physical or mental condition that temporarily or permanently reduces your ability to financially support yourself. So that's just a mental or physical condition that temporarily or permanently reduces the ability to financially support oneself. It's not permanent disability. It's not total inability to work. And that's the legal standard for getting out of that work requirement. So you can prove disability if you've applied for or are receiving disability benefits. If you're enrolled in a program for people with disabilities like the Division of Vocational Rehabilitation here in New Mexico, if you have a note from a medical or mental health professional, we have a form that includes uh, an easy way to get that note. If you're chronically homeless, you also qualify for this unfit for work, and we'll discuss that a little more in a sec. So, or your disability can be clearly visible or apparent to the agency worker doing the interview, and that will qualify you as well. So, people receiving disability benefits are generally known already to the agency. and the state agency has a form that any healthcare provider can fill out, but we'll again provide you with our form as well. So generally, one of the changes to the federal rules was that where um, homeless people were previously just exempt from work requirements across the board, the federal rules took that general exception away. But the unfit for work um, exception has remained, and the state of New Mexico is defining chronic homelessness as being consistent with that unfit for work definition. So someone who is chronically homeless does not have to meet the work requirements. So someone who's chronically homeless when they've been homeless for more than 6 months, when they've been homeless more than one time in the last year, or when they're unable to meet basic necessities of everyday life. So that includes shelter, food, clothing, heat, lights, running water. And the link to that state policy is provided here. So for those who are subject to the work requirements and do not meet an exemption, you have to prove that you are meeting the basic work requirements. This means that you have to provide the state with documentation that you're working, volunteering, or in a qualifying training program for at least 80 hours a month. So some training programs are offered by the New Mexico Department of Workforce Solutions. If you're in a program like that, you will need to let the state agency know. So in many states, agencies run SNAP specific programs called employment and training programs that are designed to help people meet these requirements. New Mexico doesn't currently have programs for these SNAP work requirements that meet the federal requirements, but they've said they're working to implement those. The last timeline we heard was that the state was going to have those by August of this year. So if you need to show that you are meeting work requirements, it's important to know you can do it in a couple different ways. You can prove you're being paid or that you're working for wages by turning in your paychecks, pay stubs, timesheets. You'll only need to do that if the state agency can't already access those records. You can use a letter or any written statement showing that you're volunteering, signed off on by your volunteer supervisor. Or you can prove that you're doing volunteer work for someone, prove that you have done work for in-kind exchange. The state agency defines acceptable unpaid work as work that gives a person experience in a job or industry, tests a person's job skills, or involves volunteer time and an effort to a not-for-profit organization. So the state agency has an existing form you can ask for called an ABOD 002 that can help you document this type of work. We also have a form linked on our website where you can where an individual could record their worker volunteering. So if someone needs help and wants the agency to call someone to verify information, for example, they can ask for help and the agency has to meet them to help. So if someone's subject to work requirements and they are not exempt, there are penalties for not meeting those work requirements for a 3-month period that include losing SNAP benefits. So the penalty of losing your SNAP benefits is effective after you have 3 complete months of not meeting work requirements. Those 3 months don't have to be in a row, like we said. It can be 1 month working, 1 month not. And once you reach 3 months, you get kicked off. Once you're terminated, you can get your SNAP back by either complying with the work requirements for 30 days, or you can become exempt from the work requirements if you suddenly became disabled. Say you would not have to meet work requirements and you would be able to get back on SNAP if the only reason for getting kicked off was not meeting work requirements. Or if you waited until the end of the 3 year lockout period that applies to everyone at the same time. If you reapplied at the end of that 3 year period, at the beginning of a new 3 year period, you would get back on SNAP. Um, if you get back on SNAP by like becoming exempt or complying with requirements and you fall off again, you will get 3 more months on SNAP, but those are just the secondary 3 months is just consecutive, and then it will not reset again during that lockout period. So if your benefits are terminated, uh, next slide. If your benefits are terminated because you're not meeting work requirements, other household members will still get benefits, but the amount will be reduced for the household because there will be one fewer beneficiary. So, for example, if two parents who have a 16-year-old child will both have to meet the work requirements if they're not otherwise exempt. If one of them doesn't meet work requirements for 3 consecutive months, the household's benefits would be reduced to be just for those two people who are still qualifying for SNAP instead of for the full three. So if you have your benefits terminated, you can seek legal help by contacting the New Mexico Center on Law and Poverty or New Mexico Legal Aid. All right, it's important for people to know their rights in the application process. The state agency has to screen all applications and program participants for exceptions when they apply, and they have to recertify and verify that they're meeting their obligations to screen for all those exceptions. The state agency has to offer help to all individuals and help them document compliance and exceptions. They have to provide an explanation of the work rules in writing and verbally in an interview. They have to evaluate whether there's a good reason why someone could not comply with work requirements. And if so, they have to not count a month toward the 3 month time limit for good cause. And one of those good cause reasons can be anything that's impacting someone's ability to meet requirements that's out of their control, like illness or lack of transportation or death of the family. So that's a general outline of some of the recent changes to SNAP and what those work requirements look like for people. So we're going to take a pause for questions.
Yeah. And this portion we're going to be doing through the chat as it is being recorded. So please put your questions in the chat, and then we will have an open Q&A session at the end of the presentation where we will stop recording and give you the ability to jump on screen and ask your question. But for now, we have one from Tiffany. And the question is, why would someone be terminated from SNAP for 3 months if they're homeless? Is there a way to appeal, or sorry, I can't see the rest of it. Oh, or does that work? Or how does that work? Someone I know missed their recert and then was told they have to wait 3 months.
Yeah, so I could take this one. So anyone who the rule says, so first just to address your comment on people losing SNAP even though they're homeless or applying a 3 month limit to people who are homeless, like 100% agree. That's why there's always been exceptions in the rules for people who are unhoused. The difference is now the state is choosing to carve out specific types of homelessness as essentially making someone disabled under the rule. And so it's that chronically homeless exception, which I think can be interpreted pretty broadly for people who are experiencing homelessness and genuinely have difficulty meeting these requirements. And so they should claim themselves as exempt every time so that they don't have to document they're meeting these requirements. So we really encourage people to make that known so that people who think it applies to them let the state agency know so they can act on it. If you miss your recertification, that alone should not mean you have to wait a certain period of time to reapply ever. If you miss your recertification, your benefits will terminate because if you didn't turn in a form, But as soon as you reapply, benefits can be reinstated. And in fact, if you turn in your application very close to when your recertification was due, you can be fully reinstated, and you may have a small amount of prorated benefits. Like you may not get the full month, but you get most of the month based on how soon after you're terminated you actually turn in the form. So this, what you're saying here of someone being told they have to wait 3 months, just based on what I'm hearing here, that doesn't sound right. And feel free to refer those folks to us or to New Mexico Legal Aid to get another look at what's going on there. Thank you for your question.
And Sav, I'll go ahead and put the phone numbers in the chat for both us and New Mexico Legal Aid, and then I'll put those up at the end as well. And the only other question I see right now is if the presentation and recording is going to be shared. And yes, we're going to share all of the resources, all of the links that we have referred to, and more in a follow-up email.
Well, I guess we'll keep going, and then please continue to add questions unless I see one just coming up. Noticing the lockout dates, are the work requirements going into effect May 31st? So no. So let me explain what the difference between those lockout dates. So the requirements are in place now. They started January 1st for people who are applying, and then they will be instituted on people who are currently receiving SNAP when they recertify throughout the year. So they apply to any new application or recertification in 2016. What the lockout dates mean is that after you have not met the requirements for 3 months and you get kicked off, you are locked out until the next available lockout date. And New Mexico sets these lockout dates. They're the same for everyone, no matter when you're kicked off. So the next available lockout date ends on May 31st, 2026. So for people who are kicked off in April, which we know that is happening to a number of folks because the work requirements started for most of the state January 1st. So some people didn't meet the requirements in January, February, and May and March. So they got kicked off in April. Unless they become exempt or are able to meet the requirements, those folks won't be able to get back on until May 31st, 2026. It's a nice thing, it's only a month. But after that date passes, the next lockout period doesn't end until 2029. It's a 3-year lockout period generally. So we find this is the easiest way to explain it, that these are just mandatory lockout periods. The federal government explains it as getting 3 months of SNAP in 3 years. And they describe it as a 3-month time limit. So that's the effect of that lockout period. It's very, very harsh for families. So we really encourage people to maximize exemptions. Really think if they apply to you and if you're kicked off, maybe there was a good cause why you couldn't meet the requirements, highly likely, or should you have been exempt in the first place, and to consider that. So very good question. And feel free to raise other questions that are coming up for people as we go through this. We'll go ahead and transition now to the immigrant eligibility changes that are happening in SNAP. And the big thing that happened is that starting January of 2026, only 3 categories of immigrants can qualify for SNAP. And that's people with green cards, also known as lawful permanent residents, people with status as Cuban Haitian entrants, or people with status through the Compact of Free Association citizens. And these are citizens of Micronesia, Marshall Islands, and Palau. It's a really specific designation that are working in the United States. Previously, a number of humanitarian status immigrants qualified for SNAP under federal rules. That included refugees and asylees. That is no longer going to be the case. And so unless their status has changed to one of the 3 that qualify, and typically that's going to be people get a green card. So unless those folks now have a green card, they will be either denied from SNAP when they apply, or will be terminated when they're up for recertification in 2026 if they've been getting SNAP under the old rules. And the way the state is going to implement this is as I explained, people are denied an application. Like if you go and apply today and you're in refugee status, but you don't have a green card, you will be denied SNAP. But if you're receiving SNAP, when your case is up for recertification, the state has to look at your application and evaluate and ask you to prove that your immigration status has changed, if it has. And if they don't find that you're in an eligible immigration status, you'll be terminated. But other household members can get SNAP, even if one or more people are not in an immigration status that qualifies for benefits. That household will simply get a lower amount than they would get if everyone in the household was in an eligible status. And what's going to happen, and this has always been the rule, but it's very important now as we're going through this transition, the healthcare authority has to check if immigration status has changed to something that qualifies before they deny or terminate benefits. So people should receive a request in writing for this information, and it should be discussed at the interview that's required when people recertify their SNAP. And anyone who now has a green card needs to report it to the healthcare authority if they're currently on SNAP and they've got a green card and they haven't told the HCA, the healthcare authority, this information yet. People who have a green card will be able to keep SNAP in most cases. There's a rule that some people may have heard of that is sometimes referred to as the 5-year bar. And it says that some immigrants have to wait 5 years to get benefits, and they have to wait in a certain status. This does apply to some lawful permanent residents. Some people with green cards have to wait 5 years, but there are many, many exceptions. And the biggest exceptions apply to people who are in humanitarian statuses. So those people who can't get SNAP outright anymore, as soon as they get a green card, they're eligible and they do not have to wait 5 years. So we give this slide in every presentation we give like this, not so that people memorize it, although you'll get this and can find this information on our website too. It's to show that there are so many exceptions to this so-called 5-year bar or waiting period. So people in humanitarian statuses are always exempt from this 5-year waiting period. Any child under the age of 18 that has a green card does not have to wait 5 years to get SNAP. Certain immigrants with a military connection do not have to wait. So it's really important to consider if you're told that the 5-year bar applies to make sure it's correct because there are many, many exceptions. So the state agency in New Mexico did allocate some funding to help families who are losing SNAP due to these rules. And $12 million was appropriated during the first special session of 2025. And what it's being used for is a one-time payment, but a little over $500 per household member that's losing benefits. And it will come as a one-time lump sum to the family's existing EBT card, the card they use to purchase food using their SNAP benefits. So it's important families know about this and take advantage of it. So even though we're having these restrictions on SNAP, we want to make sure people know that there are other programs that do not have immigration status requirements that are available to families, especially families with children. One important one is WIC, Women, Infants, and Children program. That's for pregnant people and households with children under the age of 5. It's administered by Department of Health. It also provides an opportunity to buy food using a card. It has to be used to buy certain staples that are associated with a healthy birth weight for kids. So it's a lot of like beans, milk, eggs, formula. It's a really important program. It's under-enrolled in New Mexico, and it does not have immigration status requirements tied to it at all. So we want to make sure people know about this program. The other for school-age kids is Sunbucks. It replaces school lunches for families during the summer that would otherwise qualify for free and reduced lunch under the federal rules. That one is administered by the healthcare authority. So if students are not for some reason fully enrolled in free and reduced lunch, they should apply with the healthcare authority. You could get a couple $100 per child over the summer to help buy food and replace those school lunches. So we want to transition quickly now to rights and protections for people when they're applying for SNAP. And these are things that apply for families that are immigrants, families that may be facing these work rules, or families that are just trying to access the program. Their federal law and our state law says that the state agency has to explain the rules to families and has to explain them correctly. Families have to be told what documents and information are needed. They have to get that in writing and be told what kinds of documents they can turn in. Like, it's not just one single document, right, to verify something. There's always options. And so the written request from the agency has to give examples and give a deadline. And they have to offer to help, and if the applicant needs help, provide it. So if someone is facing the loss of SNAP benefits and the rule that they're being kicked off for violating was never explained to them, that's something to raise. That's something that could be used to challenge the determination. Or if you didn't get a request in writing for the thing that you're being denied because you didn't turn in, that could reverse that decision if you challenge it. So we want to make sure people understand these rights in the process to fully understand what's required of them to get approval. People, of course, have the right to receive help in the language they speak. So that means an interpreter at no cost and in all languages. So it's a really important, because of advocacy that was done by many organizations in New Mexico, the healthcare authority includes a piece of paper in every notice that tells you how to get an interpreter, and it lists the top 20 languages spoken in New Mexico. And if you call the number associated with the language you speak, you get a voicemail in that language, and you can get a call back from a worker with an interpreter in that language. And that has to be provided no matter what the language. People should never be asked to bring a family member or a friend to interpret, especially in a setting where healthcare related information is shared. And then importantly, in New Mexico, because of the high number of people that speak Spanish, Vietnamese, and Chinese languages, the written application and written information must be provided in those languages. So families should, if families predominantly speak Spanish, for example, and receive a termination notice or an information request notice only in English, that is a reason to challenge a negative decision if that happens in your case. And we have important resources on this that can be shared out in the community in multiple languages that are linked in this presentation and we'll provide after as well. The other thing that's super important is, of course, is that mixed status families can apply for the people in their household that qualify. So it's very common, right, that family members may be in different immigration statuses. Some may qualify for benefits, some may not, either because some household members may be undocumented, but also maybe some household members are subject to that 5-year bar, but there are kids in the house too. And so they can qualify right away, maybe the parents don't. When parents or anyone is seeking benefits only for other household members who qualify, the people who are not applying to receive the benefits never have to provide their own Social Security number or immigration status documents. The application makes this clear that this isn't required, but it's really important for people to know, because if it's not clear, they may be chilled from applying for their kids, for example, if they think they're going to have to give information about their own status or be required to provide a Social Security number. In fact, the agency cannot even track the cases by Social Security number. So a parent who calls about a case that's just for their child should be able to call up the case just based on the name and date of birth of their child. So it's important to know the way the state agency verifies immigration status. The application asks for specific information about people who are seeking benefits. So it asks for their immigration status specifically. It also asks for their A number and date of entry. To the extent the state can, they will verify this information and should verify it electronically. There's a database the state accesses that either confirms that the information the person put is true or says that that doesn't look correct. It does not return information about the person to the state agency, and it is not used to collect information about people. It's merely a way to check, and it's a system that's set up specifically just to verify eligibility for benefits. One barrier that families may face is documenting income. So all household members have to prove that what their income is to determine who can get benefit, to determine if the individuals who are seeking benefits can qualify. So even a parent who maybe is not in a status that qualifies for benefits, even if they're applying for their kids, right, that parent's income needs to be documented so that the state can determine the household income. But that does not have to be documented in one way. So pay stubs are one way to verify income for people who are employed, but people don't always have those, right? Some folks are paid cash. Some people may have an employer that doesn't want to. Some people are paid cash. Some people may be given checks and they just don't have the pay stubs anymore. They can ask for a letter from their employer, but some employers may not want to do that, or a worker might not feel safe asking their employer for that a type of a letter. So there are alternatives. If those forms of documentation are not available to the person, they can get a letter from someone who knows their household documenting what their income is. That could be a case manager, that could be a coworker, could write a statement. That's called a collateral contact under the rules. And if that's not available, the state agency must accept a sworn statement from the person about what their income is. And this is used very commonly by people who work in the gig economy, who may make money selling things, or are otherwise paid cash, like for cleaning houses or something like that. It's very commonly used and is permitted under the rules as a way to verify income if the other avenues are not available. It's really important for people to know that their employer can be called if that's helpful. The agency can call the employer to verify income, but will only do so and should only do so if the applicant gives permission, because we have seen that cause problems. And of course, a social security number is not required to verify income. It can be helpful if people have it because it allows the agency to check certain databases, but of course it's never required and shouldn't be. Many people legitimately are concerned about whether getting SNAP benefits could hurt their immigration status. And we hear this a lot in the community. And I think what people are referring to is the public charge test that exists in our federal immigration system. And what the public charge test is a test to see if certain people who are applying to get green cards or people applying to renew visas or come into the country are going to rely on the government as their main sources of support. There's a common misconception that public charge affects the ability to become a citizen. That is not true. It affects people's ability to get a green card. Now, there have been some changes proposed to the public charge rules, but those are not yet in place. And we want people to have good information and not be unnecessarily deterred from getting benefits. The first thing to know is that most people never have to worry about this public charge test. That's because it doesn't apply to everyone. One, it is only applies if you're seeking a green card, but there are also many exceptions, and it's largely people in those humanitarian statuses that are exempt from having a public charge test. And so even if they don't have a green card yet, if they came in as a refugee, this is not a concern. The third thing that's important to note is that it doesn't apply to all benefits, so we'll talk about that. What we see is that the public charge test really comes up for people who are seeking green cards through family or entering from outside the US, where this could really come up. But if for families who don't have a green card and are thinking of applying, if you're encountering that out in the community, that's maybe to consider sending them to an immigration attorney before they submit an application. But it's really only going to be for certain benefits. Under the current law, there's only two types of benefits that count in a public charge test. And that's long-term institutional care paid for by Medicaid. So that's like in a nursing home or a residential facility for a month or more. And then ongoing cash assistance. So TANF or GA are two types of cash assistance administered by the state, or SSI, which is a means tested disability benefit provided by the Social Security Administration. It does not and will not consider currently emergency Medicaid, exchange coverage, SNAP, food stamps, unemployment benefits, tax credits. None of this is a part of a public charge test. Now, the proposals that have been raised by the Trump administration, which came out in November to end the current public charge rule, and the current rule is what limits it to just institutional care Medicaid and TANF or cash assistance. To remove that rule that limits it to those two benefits and not replace it with anything. And that really doesn't provide clear information about what would be considered. There was a lot of opposition to that rule. The federal government is wading through that. They have not issued a final decision on what they will do. For now, the rule hasn't changed. And those exemptions we mentioned earlier from people in humanitarian statuses and the fact that it only happens when you get a green card, that isn't even a proposal to change. So what we want people to know right now is that for those folks currently receiving benefits, stopping them now is very unlikely to impact your immigration status or create a public charge determination. But of course, every family has to make the best decision for themselves. For folks who are seeking a green card, that's something maybe to discuss with an attorney. If the rule does change, there will be an effective date, which will give people time to decide what they want to do. But looking forward with the changes in who qualifies for Medicaid in the future, right, starting in January 2026, and by the end of the year, only people with green cards, Cuban Haitian entrants, and COFA immigrants will qualify for SNAP anyway. So the impact of this rule on SNAP in particular is really limited, but we want families to have good information. We also just want to raise, if SNAP is denied, people can appeal. It's not a formal legal process. It's informal. It requires the agency to take another look at your case. And if you still don't think it's right, you can sit through a meeting with an administrative law judge and explain that. We always encourage folks to seek legal help. We're available at Center on Law and Poverty and New Mexico Legal Aid. All of the resources we shared today and many other resources related to SNAP are in a blog that links through all the various resources we've created. There's a toolkit on the work requirements and more. Thank you, Rita has posted some information in the chat, and it'll be included with what we're sending around here. I just want to briefly mention two things that New Mexicans can do to address, or that New Mexico can do to address and prevent harm from these rules. One is making sure our state gets a low barrier employment and training program available in New Mexico so that people subject to these rules and then the rules that are coming for Medicaid have access to a program that they can participate in when they don't have ready access to employment to meet the requirements, especially for people who might have difficulty meeting an exception. The other thing is for the state to not just do a one-time payment to families who are losing benefits due to these rules. We know that hunger is not a one-time need, and that the food insecurity that people are experiencing, despite the fact that they're working, despite the fact that families are doing all kinds of things in the community, taking care of other family members, that food assistance is an important way that we take care of each other, and that should be funded ongoing. So it's important that New Mexico take a look at how to address the ongoing need for food assistance, not just a one-time payment. I'll hand this over to Rita to wrap us up.
Hi, let me see if I can get on the spotlight. so people can see me. I am putting my contact information in the chat. We are committed to language access and we want to make sure that this information is available in other language. As Sav mentioned before, we have it's all Spanish session happening with this exact information, but without the use of interpretation in May. So please look out for that to share with your communities if you think it would be beneficial to them or they couldn't make it this time. And we are also happy to coordinate with any of you or any other partners that would like to have this information presented to a group in another language. So please do feel free to contact me if you're interested in collaborating.
Thank you so much, Rita.